civil rights struggles that preceded us, one of our most important obligations is to remember, reflect, and honor those who fought those battles for our benefit. To think about the generations of women who devoted so much of their lives to securing the right to vote is both humbling and inspiring, as is reflecting on the subsequent generations who worked just as tirelessly to ensure that all women, including Native women and women of color, could legally, freely, and safely exercise that same right. The work of the suffrage movement helped perfect our Constitution and permanently strengthen our democracy. We honor that movement and those who helped lead it by being here today, by saying their names, remembering their struggles, reflecting on what they achieved, and recognizing the important work that came after the 19th Amendment's ratification. That's why I'm so grateful to all of you who have taken time to be here today and chosen to celebrate Constitution Week by reflecting on the work of Americans to ensure that our country lives up to the values expressed in our founding document. With that, I want to turn things over to our featured presenter today, Professor Jill Hasday. Professor Hasday is a distinguished McKnight University professor and the Centennial Professor of Law at the University of Minnesota Law School. She has authored 2 books, including 2019's Intimate Lies in the Law, which won the Scribes Book Award for Best Work of Legal Scholarship. Professor Hasday's presentation today is titled Myths About the 19th Amendment. Professor Hasday, thanks so much for being here today, and I will now turn the virtual podium over to you, Professor.
Thanks so much for having me. Can everyone hear me? You can hear me? Good. Okay, so thanks very much for having me. I'm delighted to be here. As the Chief Judge said, I've been a law professor at the University of Minnesota since 2005. My work focuses on anti-discrimination law, constitutional law, family law, and legal history. My subject today is the 19th Amendment. This amendment, ratified 100 years ago on August 18, 1920, provides that, quote, "The right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of sex. Congress shall have power to enforce this article by appropriate legislation." I'm interested in the history of the 19th Amendment, and I'm even more interested in how Americans remember and misremember that history. I'm going to focus my comments for today on 6 central myths about the 19th Amendment. Exploring these myths will help us better understand the amendment and how Americans have thought about it over time. The first myth is that men simply gave women the 19th Amendment. This is a common way of talking about improvements in women's status in the United States, with politicians, judges, and other commentators attributing reform to what I call men's spontaneous enlightenment rather than women's struggle. Spontaneous enlightenment stories report that men decided, essentially on their own initiative, to improve women's lives and give them more rights. In these stories, men are the key actors and women the acted upon. In fact, American women seeking to better their lives have never been able or willing to wait passively for men's enlightened benevolence. Male-dominated society did not spontaneously or naturally recognize the problem of women's inequality. Instead, women have secured new rights and opportunities by identifying grievances, demanding change, and combating powerful opposition. Winning the 19th Amendment required generations of women's activism, mobilization, perseverance, and bravery. Suffragists had some male allies, and they needed them. Men controlled every lever of power and every political institution. But overall, the suffragist movement encountered enormous resistance from men who opposed changes in women's status and women's legal rights. The first Women's Rights Convention in the United States, which met in Seneca Falls, New York, demanded women's suffrage as early as 1848. Women's rights activists steadily pursued the issue for decades, despite endless ridicule and harassment. After the Civil War, suffragists hoped that their loyal work for the Union cause would be rewarded at war's end with female enfranchisement. But the so-called radical Republicans behind the Reconstruction Amendments refused to extend the vote to women. The 14th Amendment, which was ratified in 1868, is most well known today as the source of the Equal Protection Clause and the Due Process Clause. But the 14th Amendment was also the first part of the Constitution to include the word male. Section 2 of the 14th Amendment provides that states would be penalized for denying the vote to adult men, but allowed states to continue to deny the vote to women without suffering any penalty. The inclusion of the word male in the Constitution was both a bitter defeat and a stunning mark of recognition for the women's rights movement. The founders began the Constitution with the words, "We the people," without experiencing any anxiety that that would actually support equal rights for women. But by 1868, men knew they had to place the word male in the Constitution to keep women from being enfranchised. After this setback, suffragists regrouped and spent the next 52 years relentlessly pushing for the vote. Here's how Carrie Chapman Catt, the president of the National American Women's Suffrage Association, or NAWSA, described the Causeless Campaign that suffragists had to undertake after the 14th Amendment permitted women's continued disenfranchisement. Catt reported that between 1868 and 1920, suffragists, quote, were forced to conduct 56 campaigns of referendum to male voters, 480 campaigns to get legislatures to submit suffrage amendments to voters, 47 campaigns to get state constitutional conventions to write women's suffrage into state constitutions, 277 campaigns to get state party conventions to include women's suffrage planks, 30 campaigns to get presidential party conventions to adopt women's suffrage planks, and 19 campaigns with 19 successive Congresses. As Catt recalled in 1920, hundreds of women gave the accumulated possibilities of an entire lifetime. Thousands gave years of their lives. Hundreds of thousands gave constant interest in such aid as they could. It was a continuous, seemingly endless chain of activity. Young suffragists who helped forge the last links in that chain were not born when it began. Old suffragists who forged the first links were dead when it ended. NAWSA, with Catt at the helm, was the more moderate suffrage group. Alice Paul led the more aggressive wing of the suffragist movement, the National Woman's Party, which was the first group in America to employ the strategy of picketing the White House. National Woman's Party members who picketed in the years before Congress passed the 19th Amendment were beaten by police, attacked by mobs of men and boys, arrested while their assailants went free, brutalized in prison, and force-fed. For example, here's how a suffragist described the picketers' ordeals on August 15th, 1917. Quote, Alice Paul was knocked down 3 times by a sailor in uniform and dragged the width of the White House sidewalk in his frenzied attempt to tear off her suffrage sash. Sailors also knocked down other suffragists. One woman was struck by a soldier in uniform and her blouse torn from her body. The next day, 50 policemen led the mob in attacking the women. Hands were bruised and arms twisted by police officers and plainclothes men. Rather than protect the peaceful protesters, the police fell upon these young women with more brutality even than the mobs they had before encouraged. Okay, so the first myth about the 19th Amendment is that men simply gave it to women. This leads to my second myth, that the 19th Amendment was inevitable. Soon after the 19th Amendment was ratified, textbooks began describing enfranchising women as a logical inevitability. To quote one textbook, since the United States wanted to be democratic, since the United States wanted to govern according to the wishes of its inhabitants, it was clear that sooner or later, political rights would have to be extended to women. Assumptions about the inevitability of women voting became easy to make after the 19th Amendment was no longer controversial. But those assumptions gloss over the uncomfortable reality that many Americans at the time thought democracy did not require female voting. The 19th Amendment passed the Senate on June 4th, 1919, with just 2 votes to spare. Ratifying the 19th Amendment required agreement from 36 states, so supporters could afford no more than 12 holdouts. By the time Tennessee became the 36th state to ratify, 8 states had already rejected the amendment. Winning Tennessee took tireless campaigning that almost failed. The Tennessee House approved the 19th Amendment with no votes to spare. This leads to my third myth, that the 19th Amendment was only about voting. So why exactly was the battle over the 19th Amendment so intense, hard-fought, and close? It was because all sides understood the suffrage issue as about more than just voting. The battle over women's suffrage was a referendum on women's status under the law and women's place in society, including in the family. That's the through line that connects all the anti-suffrage arguments, even when they seem to contradict each other. I'll read now from my favorite suffragist poem, written in 1915 by Alice Duer Miller. It lists some of the key suffrage arguments, the arguments explaining why women shouldn't have the vote. The poem takes the form of a list. 1, because no woman will leave her domestic duties to vote. 2, because no woman who may vote will attend to her domestic duties. 3, because it will make dissension between husband and wife. 4, because every woman will vote as her husband tells her to. 5, because bad women will corrupt politics. 6, because bad politics will corrupt women. 7, because women have no power of organization. 8, because women will form a solid party and outvote men. 9, because women and men are so different that they must stick to different duties. 10, because men and women are so alike that men with 1 vote each can represent their views, and ours too. Suffrage was an intense struggle over women's status, about whether women had an independent place in society separate from their roles as wives and mothers. Today, though, we only remember the 19th Amendment when we remember it at all as about voting. One reason for this is that courts have interpreted the 19th Amendment very narrowly to create only a voting rule that has no implications for any other legal questions associated with women's equal rights. If the third myth about the 19th Amendment is that it was only about voting, the fourth myth about the 19th Amendment is that it actually gave women the vote. That's not true for 2 reasons. First, the federal Constitution doesn't guarantee anyone the right to vote. The Supreme Court held that in an 1874 case called Minor v. Happersett. Under the federal Constitution, the fact that you're a citizen doesn't give you the right to vote. States are in charge of voting qualifications, even in federal elections. Rather than franchise anyone, the federal Constitution only prohibits certain kinds of voting restrictions. So, for example, the 15th Amendment prohibits voting restrictions based on race, although that prohibition wasn't actually enforced for a century. The 26th Amendment prohibits voting restrictions based on age, as long as the voter is at least 18 years old. And the 19th Amendment, along these lines, prohibits voting restrictions based on sex. So the first point, is that the federal Constitution doesn't guarantee anyone the right to vote. The second point is that the 19th Amendment's prohibition on sex-based restrictions on the franchise didn't end race-based obstacles to voting. Indeed, many women of color remained disenfranchised for decades after the 19th Amendment was ratified. For example, it wasn't until 1924 that Congress provided that all Native Americans born in the United States were citizens with the right to vote. For decades after the 19th Amendment, Congress also continued to impose a multitude of racial prohibitions that made some immigrants, especially from Asia, ineligible for naturalization and hence voting. The last of these statutory bans wasn't repealed until 1952. African American women were theoretically eligible to vote in 1920, but they were often denied that right in practice through a variety of strategies, including voter intimidation, grandfather clauses, and poll taxes. The federal government didn't take real steps to combat the systematic disenfranchisement of people of color until the enactment of the 1965 Voting Rights Act. That leads to the fifth myth about the 19th Amendment, that all the suffragists were white. Women and men of color were early and energetic supporters of women's enfranchisement. Frederick Douglass attended the 1840 the 1848 Seneca Falls Convention. When the participants hesitated about adopting a plank favoring women's suffrage, he rallied them and urged them to include it. Sojourner Truth was both an abolitionist and a women's rights crusader. Many African-American women, including Ida B. Wells Barnett, also used their club and college networks to support women's enfranchisement. Ultimately, however, the white-dominated suffrage organizations like NASA and the National Woman's Party decided to seek the support of Southern segregationists by assuring them that the 19th Amendment would not mean that African-American women could vote. These suffragists told segregationists that African-American women would remain disenfranchised through the same strategies used against African-American men. Even worse, after the 19th Amendment was ratified in 1920, and white suffragists didn't have to worry about getting support for that anymore, they didn't turn their attention to making sure women of color could actually vote. They acted as if the 19th Amendment had enfranchised all women and moved on. I'll turn now to the sixth and final myth that I'll discuss today. This myth tells us that the women's rights movement of the 19th and early 20th centuries was a complete success, that women got everything they asked for then. This premise fits with the larger cultural narrative in the United States. Politicians, judges, textbook authors, and commentators have been announcing that America has achieved sex equality since even before the 19th Amendment was ratified. Women did succeed in winning the 19th Amendment, but the larger agenda of the 19th century and early 20th century women's rights movement remains unfinished to this day. Some of the legal reforms that 19th century feminists fought for still haven't been fully achieved. For example, women's rights activists have spent more than a century and a half arguing that wives should have legal dominion over their own bodies. Indeed, the leaders of the 19th century women's rights movement often insisted that establishing a wife's right to sexual self-possession was even more important than the vote. Women made essentially no progress on this issue in the 19th century. It wasn't until the last quarter of the 20th century that feminists finally won modifications of the common law rule that had completely exempted husbands from prosecution for raping their wives. However, at least 21 states still treat marital rape more leniently than rape outside of marriage. Even now, we haven't completed a legal reform that women began arguing for publicly in the 1840s. Moreover, women in the first wave of feminist mobilization didn't only want legal reform, they also wanted economic equality and equality of political participation. At the end of 1922, a newspaper asked Alice Paul to predict how modern feminism would shape the course of history in the next 100 years. Paul, the leader of the National Woman's Party, forecast that it would not require 100 years to elect a woman president of the United States, and that women would comprise half of the membership of Congress by 2023. He predicted that women and men would have the same economic opportunities within 100 years. In short, she was hoping and striving for a world where women participate equally in the control of government, of family, and of industry. In 1923, Paul launched her campaign for the Equal Rights Amendment she had drafted. Paul wanted the Constitution to declare that men and women shall have equal rights throughout the United States and every place subject to its jurisdiction. America has not reached many of the milestones that Paul thought would already be behind us. We have never had a female president. Women have never filled even a quarter of the seats in Congress. The median earnings for a woman working full-time and year-round in 2019 were just 82% of the median earnings for a male full-time year-round worker. Black women earn just 63% of white men's earnings, and Hispanic women earn just 55%. People living in families led by an unmarried woman are more than twice as likely to be poor as people living in families led by an unmarried man. Less than 8% of the chief executives at Fortune 500 companies are women. After almost a century of feminist advocacy, our Constitution still does not include an explicit commitment to women's rights. Okay, so I'll wrap up. I think our misremembering of the history of the 19th Amendment fits into a larger pattern that I'm writing a book about now. Too often, America's stories about itself exclude women's struggles for equality. Politicians, Supreme Court justices, textbook authors, and other commentators constructing and disseminating these stories either ignore women's struggles entirely or distort them beyond recognition by insisting that women have already won. I'm speaking with you here today because I believe that remembering women's struggles more frequently and more accurately can help the nation advance towards sex equality. The stories America tells about itself help shape our beliefs about what is possible and what is necessary, what must change and what cannot be altered. Incorporating a richer and truer history of women's struggles for equality into our collective memory can sharpen our understanding of how reform takes place, focus our attention on the battles that are still not won, and fortify our determination to push for a more equal future as we shape the next chapter in this American story. Thanks for your attention. I look forward to your questions and comments.
If you have a question, please enter it in the chat box. We have one already. What was the name of the 1870s Supreme Court case holding that there is no right to vote under the federal Constitution?
Okay, Minor v. Happersett. That's actually a really interesting case. So, as I said, the women's rights movement was bitterly disappointed by the 14th Amendment, which in Section 2 explicitly says that states will be penalized for denying the vote to men. Not that penalty was ever actually enforced, but in theory, they would be penalized for denying the vote to men, but not the vote to women. And it seemed like a bitter defeat. But then the suffragists, ever resourceful, came up with a new strategy, which they called the New Departure. And the New Departure contended that, in fact, despite Section 2 of the 14th Amendment, women had been enfranchised after all, because Section 1 of the 14th Amendment guarantees every citizen of the United States the privileges and immunities of citizenship. And Virginia Minor, a suffragist, said, well, what's the core privilege and immunity of federal citizenship? It has to be the right to vote in federal elections. This was actually, I think, a pretty plausible claim in that the court had previously held in a case called the Slaughterhouse Cases that privileges and immunities of federal citizenship were about those aspects of being a free person that particularly related to the federal government and access to the federal government. What's more important in terms of access to the federal government than the right to vote in federal elections? So they went forward. Virginia Minor went forward with this claim. The Supreme Court said absolutely not. Basically, it read the Privileges and Immunities Clause to have no practical consequence, which remains the case to this day. And that has consequences not only for women who are arguing for their vote in after the 14th Amendment, but to this day. One question you can ask yourselves: why are states in charge of voting qualifications, even for federal elections? Minor v. Happersett is an important part of that. Is an important part of the answer to that.
Thank you. Our next question is, why is there such reluctance to take a clear-eyed view of these issues and actual accounting of our history?
Well, one, I think the dominant story is in some ways very pleasant, especially if you want to defend the status quo, because the dominant stories, especially the one women's equality has been achieved, tells us no more change is necessary. That is a theme you see in mainstream. As I'm working on this book, I was just looking at mainstream newspapers and magazines have been telling that women have been emancipated story since the 1800s. But you also see it put to political use. So for instance, one of Phyllis Schlafly's key arguments against the Equal Rights Amendment is that it was unnecessary because women's equality has been established. And that has been a continuing through line in anti-feminist political mobilization. Nothing more is needed because women's equality has already been established. So I think that's part of the appeal. But also I think we like to believe that how could it be the case that things women started asking for over a century ago are still not there? That's just a very different vision of how responsive America is to women's claims.
Our next question follows on that quite well, actually, and it's a two-part question. Just what would the ERA do for me that the law does not already provide in terms of my equality before the law as a woman? And is there any downside to the ERA for women or men?
Okay, so that's an open question. So one argument that people have made, which is more plausible now than when Phyllis Schlafly made it, is the Supreme Court has ultimately interpreted the Equal Protection Clause to extend to women. That took 103 years, but eventually they did it. And ultimately everything women got under the ERA, they got under the Supreme Court's interpretation of the Equal Protection Clause. In fact, virtually every nightmare of horribles that Phyllis Schlafly anticipated from the ERA has already come to pass without it. So she was worried about the end of sex-based alimony laws. They're gone. She was worried about same-sex marriage. We have it. The only thing that she thought the ERA would mean would be the end of the male-only military registration in the draft. That's still in place, but at this point, I personally think that's unconstitutional. But at this point, there's no combat restrictions on women's service. So on one account, everything that the ERA would have done has already happened. On the other hand, the Supreme Court, in interpreting women's status under the Equal Protection Clause, has never given women the highest level of protection that's extended to laws drawing distinctions based on race. One theory of why not is that the court never really thought that Equal Protection Clause was really about sex discrimination. It always thought it was only really about race discrimination. That was the core. Including an equal protection claim would establish that sex discrimination is a constitutional concern. And I also think it has symbolic power. Women's rights are essential, or everyone's rights really to be free from sex discrimination are essential concern of the Constitution. And women's struggles for equality are a central part of the American narrative. Interestingly, modern opponents of the ERA, so in Congress, think that quite a bit would change with the ERA. Their main argument lately has been that the ERA would give constitutional protection to women's abortion rights that they don't have through the 14th Amendment.
Our next question is, I've read about voter suppression in the 2020 election. Is there any reason to think this is more prevalent than in previous elections or more likely to succeed this time, especially as this may affect women and non-white voters?
Well, I mean, I'm not a voting rights expert, but there are arguments that right now we're seeing replays of some classic strategies. So I can talk about one case. So Florida just ended felon disenfranchisement, meaning that the fact that you've been convicted of a felony doesn't prevent you, is no longer a lifetime ban on voting. Once you're out of jail. And this seemed like a big move forward in terms of access to the ballot. But the Florida legislature passed a statute saying, okay, you're out of jail, you're eligible to vote, but only if you pay your past due fees. So those fees can run into the thousands, 10,000s of dollars. Most people who get out of jail, and before they went into jail also were indigent, right? They have no way of paying. So that was challenged on the ground that it was illegal poll tax. Poll taxes are now actually unconstitutional, the idea that you should have to pay to vote. That's been a classic strategy for voter suppression, especially of poor people and people of color. Critics of the law said this is just a poll tax. For me to vote, I have to basically pay my $10,000 fine. The federal district court, the federal appellate court for Florida, 11th Circuit, said that's not a poll tax because it's not paying to vote, it's just paying to kind of finish your criminal sentence. So someone who's a critic of that Florida law would say it's just, we're seeing the same tactics, just different versions of those tactics. On the other hand, I think it's hard to match the voter suppression you had in southern states in, say, the 1950s, where you would have Black people might be a majority of the population. In Alabama, you had like 100 of them registered to vote. I mean, that's a level of voter suppression we don't have now. I'm not saying the problem is over, but that's like peak voter suppression.
Our next two questions are actually pretty similar, so I'm going to ask them together. Do you think we would see any difference in how courts interpret reproductive rights if the ERA was adopted? Would the ERA solidify abortion rights or help at all?
Okay, so right now, the Supreme Court thinks of abortion in privacy terms as part of the right to privacy protected under the Due Process Clause. And to date, the court has resisted thinking about abortion in sex equality terms, about the idea being that women can't be equal citizens if they can't control whether they're pregnant and when they become mothers. I think adding an ERA would boost the idea that abortion should be understood in sex equality terms. And as I said earlier, opponents of the ERA seem to think that too, that adding constitutional commitment to not having your rights denied based on sex, they think suggests more robust constitutional protection for abortion rights. That said, one thing I want to say is every constitutional provision is even first it has to be fought to get into the Constitution, and then it's fought over its meaning, both in the courts and outside them, as people discuss and debate. So I think it's the wrong idea to think like the ERA would end every debate. It wouldn't end every debate, but there'd be a new ground on which people would be debating.
The next question here, you talked about myths about the 19th Amendment, but are there lessons from the suffrage movement we can still learn from today?
Oh, that's a nice question. I think the main lesson I take is that we should be simultaneously impatient with the pace of change, but committed to the long haul. I mean, women's suffrage in retrospect seems so obvious. And of course they were going to win. But in fact, the only reason they won is because they devoted themselves to it for 72 years, during which time, most of the time, they were ridiculed, harassed. Sometimes they were even beaten, force-fed, etc. Once they won, it seemed obvious. And of course, men just gave it to them because they realized that it was unjust not to have it. But making that obvious and common sense required tremendous work over the long haul. So for me, I take it as, I don't want to be too Pollyannish, but don't get discouraged if you don't immediately win. Most significant reforms for women's rights and women's status took an enormous amount of time. That, in retrospect, at least to me, seems like way too much time than it should have taken.
Another question along those same lines, what aspects of the suffrage movement, i.e. organizational efforts, information distribution, dispelling myths about women, can we use today?
Oh, well, they were super organized, and they used more than one strategy. So at the time, the National American Women's Suffrage Association, which is the more moderate group, and the National Women's Party were annoyed at each other, because the NASA women felt that these crazy heads, picketing the White House are making us look bad and it's not reasonable. But in retrospect, it's clear, at least in my view, that you needed both groups. So NASA was extremely organized at working within the system. This is the year before computers. They had cards, little index cards for every congressperson. What, their likes, their dislikes, where their wife got their hair done, everything. And they systematically used it to effectively lobby. One of them had the good fortune to be living next door to the Speaker of the House. They used everything. So they very strategically worked within the system at the same time as the National Women's Party was picketing outside the White House, getting arrested, and pushing it in a different way. So that actually having a variety of approaches can be a very good strategy, even if at the time it makes people are often mad, because they think you're pursuing the wrong strategy. Similarly, there was a break. Suffragists had a split a little earlier on about, should we pursue a state-by-state strategy where we try to enfranchise women state by state, or a federal constitutional amendment? And there's arguments to say on both sides. But again, actually, both strategies paid off in that. Why does suffrage finally squeak through the Senate? Basically, what happened is enough states had enfranchised women that the senators from those states needed to vote for the 19th Amendment. You now have to appeal to female voters in your state. You can't be voting against it. So it became a groundswell. Once you think it's going to pass, you have to vote for it, because you don't want to be the guy who voted against the 19th Amendment facing all these female voters. So the state strategy helped make the federal strategy work. At the same time, if they hadn't had a federal strategy, you wouldn't have enfranchised women in every state for decades. So it was both at the same time.
Okay, so we have several more questions here. One that came in just a couple minutes ago is kind of alluding to how the right to vote is connected to a discussion of abortion, and haven't women used their right to vote to oppose the ERA and abortion?
Okay, right. So one of the features of women's struggles for equality is that you've seen women on both sides. So they were female anti-suffragists. There were women who opposed the ERA. Many historians think that the ERA would have been ratified without Phyllis Schlafly. I think that's a very plausible view. It's important to keep in mind that virtually every state legislator who voted against the ERA was a man. So you don't want to overstate the role of women's opposition, but I do think having a woman at the head of that organization was very helpful, and she mobilized a lot of arguments that people found very appealing, pairing the idea that the ERA was unnecessary because women's equality was already established, and the ERA was a terrible idea because it would take women out of the homes. So I don't want to say women are a monolith, just like any other group is not a monolith. And so, I mean, so one way of thinking about it is it's just even if everyone is committed to equality, which, for instance, like Phyllis Schlafly said she was, you can have very different views about what that means. That kind of goes back to my earlier point, which is I don't think establishing the ERA would mean fights end. In fact, if I had to make a prediction, the opponents of the ERA who now say it would mean robust constitutional protection for abortion rights, I'm like 100% sure that the ERA ever gets into the Constitution, they'll say, no, it doesn't. That abortion rights and sex equality are something different.
Our next question is, with the doctrine of stare decisis essentially dead once the new court convenes next year, wouldn't the ERA give women constitutional rights rather than a flimsy right created by a case on the Equal Protection Clause that could be overturned at any moment? More a commentary than a question is the note at the end of that.
I can say something. If you're a law professor, at the end of a comment, you just say at the end, like, what do you think of that? That converts every comment into a question. So what do I think of that? Yeah, I mean, I think one argument for the ERA is that it's not subject to being overruled. I just want to say, I think it's a little, I support the ERA, and I think having it in the Constitution would be a good idea. That said, the idea that you escape judicial interpretation once you get in the Constitution, I think is a myth. The ERA, if it is ultimately put in the Constitution, will be fought over just like the meaning of the Equal Protection Clause is. You can't escape it, but it does create a new baseline, I think.
The next question is, President Trump committed to nominate a woman to replace Justice Ruth Bader Ginsburg. Does the Speaker support the nomination of the Judge Coney Barrett or Lagoa? If not, does that undermine the claim that the issue is about women?
I don't know what Nancy Pelosi has. Nancy Pelosi, you're saying? Oh, me. I'm the Speaker. Sorry. Do I support? I would have to see who they nominate and what they say. But I don't. In general, my view is that I don't support a woman just because they're a woman. I want to understand better how they interpret the Constitution. And if it aligns with mine, then I think they're great. If it doesn't, then I'm not a fan.
The next question is, predictions are made all the time as to how long it will actually take for women to have equal rights. Do you have your own, and more specifically, what is your thought on a realistic timeline and what would be required to get there?
Okay, so that's a great question. So I read, for this book I'm writing, I read so many textbooks starting in the 1800s and continuing. And there's one recently, I think it came out like 2011, and it confidently assured readers that the wage gap would be over by 2018. So in other words, nothing to worry about, it's coming. The latest studies suggest the wage gap will stay, I think, until 2059. And there hasn't been much progress actually in the last year. My own view is it's a moving target. I don't feel like, I mean, it's sad to say, but I don't think I'll be alive for the moment when sex equality is actually achieved. It's a moving target and we can make progress towards it. But I think it's wrong to think that it'll be done and then we'll never think about them. All the big issues in American life are never really done. They just evolve and are in new terms, but they're still fought over.
The next question changes gears a little bit here. What are some of your favorite books, both nonfiction and fiction, on the 19th Amendment or women's suffrage or the women's rights movement?
So a book I recommend that is a really great page turner, it's called The Woman's Hour. I think it's by Eileen Weiss. So she isn't an academic, she is a journalist, and she writes the story of how the suffragists got Tennessee to ratify, the 36th state, and she writes it like a novel. I mean, you can read it and the pacing is so great, like you almost forget that you know what happened. So I really, The Woman's Hour, Eileen Weiss, I really recommend. It's very accessible and it's exciting. And again, it reminds us that in retrospect, it seems obvious that of course the 19th Amendment would be ratified, but it almost didn't happen. As I said, 8 states had already rejected. And the suffragists didn't think they had a lot of good options left. They needed Tennessee. It wasn't like someone else was so eager. They needed Tennessee, and it was so close.
The next question is relating to before the 19th Amendment, I think. So were there two ballots back then, one for being able to vote in the state and one for voting in the federal election? Also, did any men support women for this right?
Okay, typically state and federal enfranchisement was the same, so that'd be the same ballot. But there are states in the years up to the 19th Amendment who enfranchised women partially. So particularly it was popular to let women vote in school board elections on the idea that women particularly care about children. So then there would be different ballots for those. Then there would be those elections. Was your second question, did men support? I think what you said is, did men support suffrage? Of course, there are men who support suffrage, or some early, some late. Without men's support, you couldn't have gotten the 19th Amendment. It's very hard. One way to think about how amazing the 19th Amendment is as a victory is you're convincing people to give you the vote when you don't have the vote, right? You're convincing them to do something when you're on the outside. It's extremely difficult. And it was difficult. It was difficult. It's easy to say in retrospect, of course, that was coming, but it wasn't easy at the time. Many men thought it was a terrible idea, in part because it went to the core of their understanding of women's place in society.
Next question, what enforcement legislation did Congress pass to enforce the 19th Amendment? Were there efforts by states to deny women the right to vote by other means, as was done after the 15th Amendment through literacy tests and grandfather clauses?
Okay, that is a great question. So initially, after the 19th Amendment is ratified, the National Women's Party with Alice Paul, initially they think, let's push for some enforcement legislation, which would have been great. One, it might have been a way of pushing the issue of why all these women of color are not enfranchised. It also would have produced some federal case law interpreting the meaning of the 19th Amendment, just like federal enforcement legislation for the 15th Amendment produced federal case law. But ultimately, suffragists don't pursue it. Why not? One is that NASA, the mainstream suffrage organization, I think makes a terrible mistake, and they basically disband as a women's organization and they become the National League of Women's Voters, which is much more a general sort of civic engagement kind of group. Alice Paul decides to focus her efforts on the Equal Rights Amendment. I mean, she's just won this huge victory and she thinks she can get another constitutional amendment because she realizes that the vote alone isn't enough to end women's equality. But the problem is she turns to the ERA, as I said, it's introduced in Congress with her urging by 1923. She doesn't really give enough time to do the most you can out of the 19th Amendment. So there's no enforcement legislation. So the meaning of the 19th Amendment is almost exclusively done through the states. And state courts take a variety of approaches. Some of them, for instance, like I think it was Georgia, say women can't vote in the 1920 election because it's too late. You have to register farther in advance, and they get away with that. The Supreme Court doesn't take many cases on the 19th Amendment. One, though, I will say, there's this case called Breedlove v. Georgia. It's a challenge to Georgia's poll tax. It's decided in 1938. So the court upholds the poll tax despite its obvious racial bias. And they also uphold the part of the poll tax that says everyone has to pay a poll tax except for women who don't register to vote. So this tax creates an incentive for women not to vote. You could actually get out of paying the tax if you're a woman and you don't vote. And it's challenges sex discrimination. The court says, well, it's not, at that point, the only standard for sex discrimination is it's reasonable. They say it's reasonable because women's responsibilities are home, basically, not at the polling place. So you don't have enforcement legislation. So the 19th Amendment basically withers. And most people, including constitutional law professors, when you talk about the 19th Amendment, will respond by saying, what's that? The reason they say, what's that, is there's no course in the 19th Amendment. There's not much case law to talk about. It's just not a robust area of law right now compared to the 14th Amendment.
Next question, what do you think that women can do to pursue more equal rights, specifically thinking of equal pay? How would you take on employers?
Okay, so so in general, I want to say one of the lessons of history is that organized action and mobilization is very important, right? It's not just every individual woman, it's organized efforts. Earlier this year, I testified at the Minnesota State Legislature about a proposed bill, which I think would be an important advance. This bill would ban employers from questioning job applicants about their prior pay history. And my testimony explained how asking about pay history perpetuates pay discrimination. Suppose at your first job, an employer pays a woman less because he thinks he doesn't like women or he thinks women aren't as dedicated to work, whatever the reason is. Even if you leave that job and get a new one, if the new employer asks you about your pay history, the fact that you were underpaid at your first job can haunt you for a lifetime. And the evidence suggests that this is an important way in which women's being underpaid for the same work continues. The Equal Pay Act of 1963 makes it against the federal law to pay women less. So why does it continue? One reason is that courts, including the Eighth Circuit, which is our federal circuit for Minnesota, have said it's not a violation of equal pay to pay based on prior salaries, even though those prior salaries may themselves reflect discrimination by previous bosses.
It doesn't look like we have any additional questions now. If you have any more questions, please enter them in the chat. While we're waiting for others to enter questions here, I'm just wondering if you can talk about, maybe you sort of alluded to some of the issues of the Voting Rights Act of 1964, and I'm wondering if you can kind of talk about the connection, if any, between that and the 19th Amendment.
Well, the Voting Rights Act of 1965, I see as, I don't want to say the end of the suffrage period because struggles about voting continue, but that's really when the government starts to combat systematic disenfranchisement based on race, in part by setting up a pre-clearance procedure by which whenever a state or locality wants to adopt a certain voting rule, it has to go to the Civil Rights Division at the Justice Department, and the Justice Department reviews to see will it reduce minority participation, and if it does, they can't do it. That pre-clearance strategy was very effective at stopping a variety of things that would have suppressed voting. The Supreme Court, in a case called Shelby County, decided a few years ago, struck down the pre-clearance procedure, basically saying there's not enough evidence that voter suppression is a continuing problem rather than one that's located in the past. Ruth Bader Ginsburg, who just passed away this week, is one of the things she's most famous for, and I think helped establish her as notorious RBG. She had a stinging dissent in the Colby County case where she says the majority's opinion is like throwing away your umbrella because you're not getting wet, without realizing that it's the umbrella that's protecting you from the rain.
The next question we have here is, you spoke about the exclusion of Black women in the late in the 19th Amendment fight. Do you see any potential fractures in a potential fight for an ERA, and what can we do to prevent something like that?
Well, I mean, women always come in multiple races and classes and sexual orientations and everything, just like any racial group is divided by sex and class, et cetera, et cetera. So I don't think it's realistic to think that all women will support the ERA. I guess my own view is the more you talk about what the ERA actually says, the better, right? So the ERA simply would commit the federal government and the states to not denying equal rights based on sex, and a majority of people support that. Another thing I want to say about the ERA is our amendment process requires a supermajority. So even at the time, Phyllis Schlafly, 1970s and 80s, a clear majority of the population supported the ERA, and the 35 states that ratified it before Congress's 1982 deadline represent a clear majority of the population as well. So it's wrong to think the ERA was a majority proposition always. This is the question of getting around the supermajority rules.
The next question we have here, person says, I find that there are issues that some people see as common sense in terms of equality go against really strongly held beliefs such as religious values. How would you broach that topic and try and convince another person to see another point of view and how it may be in their or their daughter's best and future interests?
Yeah, it's hard. I don't think there's a substitute for just talking about it. I mean, most people, one of the most powerful arguments for the ERA, I think then and now, is equal pay for equal work, and that the ERA would give more force to legal commitments to equal pay, which I think is a cross-cutting issue. But I don't think there's any substitution for just talking to people to try to persuade them of your view. That's democracy in action.
Our next question, please comment on the arguments used in the recent Minnesota legislative sessions to vote down the ERA.
Oh, I didn't even follow. I didn't know that. That's interesting. So they voted down an ERA for the state constitution?
I'm not sure if the person who left the question could give us a little more
I don't know
context.
the answer, but I can assure you that after this, I will be looking that up, because that is super interesting. And I have looked at a lot of other states as I've been working on this book, and there's basically two themes in the ERA. It's essentially the same thing Phyllis Schlafly said in the 70s and 80s. The ERA is unnecessary because equality has been achieved, and the ERA is a disaster because it'll give women more rights. In the modern era, the one they really stressed more than anything is abortion rights, which is something Schlafly said, but she had a lot of other arguments against the ERA which don't work because all that stuff happened.
Are there other countries that you feel have enacted a means of giving equality to women, and what could we take from those countries?
Well, other countries have very different approaches. So for instance, some countries have explicit requirements that half of the legislature be female. And it hasn't been our approach, but it is an interesting idea. California just passed a law that, I'm not going to get exactly the details right, but it's basically like every board above a certain size has to have at least one female member of the board. For reasons I can get into, I think under the court's current case law, that's probably unconstitutional law. And for that reason, California hasn't really enforced it. But I think even having that law, this idea that we're expecting at least one woman on the board, has encouraged a number of companies to have at least one woman on their board. Another thing that other countries have done, I think, much better than us, is they have a more robust social safety net, tends to help women disproportionately. Because, for instance, if you provide high quality government subsidized childcare centers, that enables women to work. It enables men to work too, but usually women are considered the secondary one who would go out of the workforce if the childcare isn't there. Similarly, pre-K is great for kids, but it's also, having public pre-K is also a way to help women work earlier.
We have just a couple of minutes left, and it looks like that's the last question I have here. If you have any more questions, please enter them in the chat. I'm not seeing any others. So thank you very much, Professor Hasday, for this discussion. If you have any concluding remarks you'd like to make before we wrap up here.
Thanks for inviting me. I really appreciate your listening and your time.
Great. Thank you so much.
Thank you, everybody. Thank you, Sarah.
Thank you.